Module 4, Covert Operations. Covert inquiries, pretexts, or operations are common forms of investigator methodology designed with the objective of ascertaining information, intelligence, and/or evidence for their clients. The main forms of covert operations are as follows. 1. Surveillance. 2. Engagement with parties. And 3. Electronic data surveillance. This might include IT systems and email. Covert ops are often considered as appropriate methodology by lawyers because it enables them to gain further information or evidence about a person or particular situation which may be advantageous to their client or may assist in greater understanding of a situation. Some examples of when lawyers use investigators to use covert methodology include the activities of a litigant, an injury matter, a family asset, childcare or payment of a maintenance matter, a restraint of trade matter, verification of staff or business partners' activities, spouses' activities, generally whether any particular claim or representation is accurate, the accurate level of business activity, intellectual property breach, and general risk management. Some relevant law to consider when planning covert operations is as follows. The law of entrapment. This relates to a person being induced to commit a crime that the person would have otherwise been unlikely or willing to commit. Criminal trespass. This involves being on someone else's property without permission and may result in criminal or civil action. Entering premises without authority. It is an offence to enter a private residence without consent of the occupier and also other locations, such as government buildings. An investigator needs to be aware of the legalities of entering premises and ensure authority is granted to avoid legal action. In Queensland, we consider the Invasion of Privacy Act 1971. This act makes it an offence to audio record a private conversation that you are not involved in. In New South Wales, we refer to the Listening Devices Act 2007. This act prohibits the recording of audio conversations without the consent of all parties, unless it is reasonably necessary for the purpose of protecting the lawful interests of the party who records the conversation. In Victoria, we consider the Surveillance Devices Act 1999. It is an offence to record a private conversation without the consent of each party to the conversation. However, the family court will sometimes allow private recordings into court as admissible evidence. In South Australia, we consider the Listening and Surveillance Devices Act 1972. It is an offence to record a private conversation without the consent of each party to the conversation. There are exceptions that may apply, such as if the recordings are in the public interest. In Western Australia, the Surveillance Devices Act 1998 states that it is an offence to record a private conversation without the consent of each party to the conversation. There are exceptions, such as if the recordings are in the public interest. In the Northern Territory, the Surveillance Devices Act 2007 states it is an offence for a person to install, use, or maintain a listening device knowing they do not have the consent, whether express or implied, of each party to the conversation to listen to, monitor, or record a private conversation to which that person is not a party. In the ACT, the Listening Devices Act 1992 states it is an offence to intentionally use a listening device to record or listen to a private conversation without the consent of all parties to the conversation. The Telecommunications Interception and Access Act 1979, with reference to intercepting calls, Telecommunications Interception and Access Act 1979 makes it an offence for a person to intercept or access private telecommunications without the knowledge of those involved in that communication. We can consider the Privacy Act 1988. There are a variety of laws under the Privacy Act that relate to the use of video and audio surveillance devices in private, public, the workplace, and general locations. There is also industrial legislation. The Privacy Act 1988 does not specifically cover surveillance in the workplace. However, the Office of the Australian Information Commissioner states when it is reasonable for an employer to monitor certain activities of staff. Internal HR codes or policies may also be relevant in line with the other legislation referred to. The Criminal Code 1899 in Queensland, Section 227A, makes it an offence to video record people without their consent in places where they expect to be private, such as a bedroom, bathroom, or change room. That's some of the relevant law to consider when planning a covert operation. We will now consider different areas of law where covert operations may be useful. Injury matters. Surveillance is widely used effectively by defendant practitioners to test claims by injured persons. Evidence is gathered to test the extent of the incapacity and generally test the plaintiff's case. For lawyers acting for plaintiffs, effective surveillance of poor work practices and public liability hazards can be helpful. Family matters. Before the introduction of no-fault divorce in the 1970s, investigators made a roaring trade in providing evidence of infidelity to divorcing couples. In some cases, going as far as staging photos for a cheating partner, desperate to prove that they are cheating. However, the majority of work and family matters do not pertain to this type of investigation, but sometimes clients are still keen to find out exactly what's going on with their partner and who it is going on with. The majority of work involves the verification of statements made. Perhaps a party is making claims exaggerating the situation or even downplaying a situation. In a particular case, 2 young children alleged that when their father had them every second weekend, he would drive them to Rockhampton, where they would share workers' accommodation and often be left on their own while their father worked all weekend, before being driven back to Brisbane to commence school in a tired condition. The father had filed sworn evidence denying this. Through extensive intelligence-based searches, analysis, and covert engagement, we could prove the day-to-day movements of the father, showing a number of trips to Rockhampton with the children contrary to his evidence. The matter quickly settled in our client's favour. In another case, the former husband was failing to disclose a large amount of assets and stock relating to a number of businesses. We carefully engaged as a potential business buyer. During a due diligence process, he allowed us to film all stock and catalogue. We also presented him with a contract for an agreed price of $345,000 for the business, with stock scheduled to the contract. He executed this and returned it to us. Obviously, we never proceeded to execute, and with the sale. However, the contract and schedule later became part of our affidavit against him, which also included all photographs of the stock of the business. In other cases, we have engaged contractors to provide services who has attested that they were not working and could not pay child and/or spousal maintenance. Covert methodology is also often used in stalking and domestic violence matters. There is also a strong desire to find out exactly what assets are owned by divorcing partners, with asset identification in strong demand. In an asset matter, surveillance clearly proved that the other side has substantial access to resources and was liquidating those resources, but denying that such conduct was occurring. Commercial law. As an example, after the business has been sold, confirming if the former owner is complying with the restraint of trade agreement and hasn't just set up again down the road may be a useful direction for covert operations. We may also consider this with regard to misleading the court. Acting for the defendants in a case, the plaintiff had been recently ordered to pay a large sum for security of costs. Upon receipt of the order, the plaintiff's legal practitioner filed a sworn affidavit with medical evidence to the effect that his client was too ill to do any business or proceed with the legal proceedings and was seeking a 6-month stay. Our clients were keen to proceed and engaged us to disprove that the plaintiff was ill. When undertaking our background preparation, we identified that the plaintiff owned a small shopping centre in a regional area. We carefully made inquiries into purchasing the shopping centre and were approached by the plaintiff, who expressed his desire to sell it. Over the period of a week, we spent considerable time with the plaintiff, carefully and legally recording all discussions. The plaintiff was clearly articulate and healthy enough to do business. He showed and provided us with many documents relating to the shopping centre, including his plan to strata title it. We then accompanied the plaintiff on a drive up to the regional area, and he allowed us to do a videotape of him presenting the opportunity to us. At the conclusion of a very articulate presentation, we advised the plaintiff that we wanted to contract for the asking price subject to due diligence, and asked him to get his lawyer to prepare a contract of sale. He agreed, however, asked for 1 week delay to allow him to dud his real estate agent out of $75,000 commission, as the property was still subject to an agent's contract and this would lapse in 1 week. Later, the plaintiff's solicitor, who had put on the original affidavit about his client's illness, provided us with a contract of sale. We never proceeded, but this contract, along with about 18 hours of recording and transcriptions, were filed and served upon the plaintiff about a week later. Covert operations may also be used in intellectual property matters. The greatest asset of a business client can be their intellectual property. The secret sauce, or 11 secret herbs and spices, can be the most valuable thing a business holds. When someone attempts to steal this, it can potentially have consequences more significant than the removal of all plant and equipment. In the past, we have been asked to identify potential breaches and confirm who has gained access to that valuable IP. Let's consider a case study. Dave was the senior manager at a development company. He had significant experience in managing, overseeing construction, and purchasing property for the company. David had recently become dissatisfied and decided it was time to strike out on his own. He had even been discussing his plans with company subcontractors who he planned on hiring. But one thing he lacked was significant financial backing, leads of prospective buyers, and independent research of land available for developing in central Queensland. However, Dave, through his current employer, did have access to databases of those prospective buyers and that research that his employer had undertaken, as well as a range of other IP that he would easily be able to use. Dave was approached by some friendly investors who were pleased when Dave proved he had access to this vital information for the potential new venture. Dave even confirmed he had no issue in obtaining copies to assist, taking them from his employer. Unfortunately for Dave, the investors were not real, they were investigators, and all his conversations were recorded. Dave's position was terminated. Covert operations are extremely useful in criminal defence matters. Tackling the most significant and most well-funded opposition means you need to be prepared with all the possible facts available. Depending on bail conditions, undertaking surveillance or covertly engaging with Crown witnesses will often bear fruit on issues of credit and matters relevant to your client's case. In a significant high-profile case, a Crown witness who had rolled on a number of accused was legally recorded speaking to a number of associates, including an investigator. During these conversations, the witness told associates that he had fabricated his evidence to police and was not having second thoughts about perjuring himself at court. Surveillance and covert operations or engagement may also be used with regard to liquidations. Surveillance and/or covert engagement often discloses the real commercial activity of a bankrupt or director. Unfortunately, investigations, particularly surveillance, can be costly and take time. They may also not provide you with the result that you are after. Our philosophy is that accurate results can be obtained quickly and costs minimised through direct engagement with the target in a covert capacity. Target development is the key to our success. In most cases, the client is the best investigator and has a high level of understanding of the problem.